Hello and welcome back to the East Carolina Law Group's Self-Help Series. This is episode 4 entitled Legal Terminology. Now the purpose behind this video, I'm just going to tell you now, is not to supplement a 3-year law school program whereby you're going to learn thousands and thousands of legal terms. However, this is basically here to help the pro se person or the person contemplating pro se representation to understand at least basic legal terms. Now, when I say basic legal terms and a law school education teaching you thousands of legal terms, one of the very first books that every 1L, that's a first-year law student, is required to purchase is this book. The Black's Law Dictionary. Now, by my estimation, the Black's Law Dictionary has somewhere in the ballpark of, 2,000 pages, pretty close. That includes appendixes and things of that nature. But it's important to know that there are certain key terms that you need to know if you're even going to consider self-representation, or even better than that, if you're going to hire an attorney when they start talking about these things, you're going to have at least a basic idea of what it is that they're talking about, okay? So we're talking predominantly from the civil side. I'm not going to get into a lot of the criminal terminology. Much of that is commonplace. Turn on Law and Order and you'll learn all about warrants and things of that nature. They're relatively simple. However, when we're talking about legal terminology, we are talking strictly from North Carolina civil procedure. So we're going to just go over some basic terms so that if you do have to hire an attorney and they're telling you about we're going to file a complaint and summons and serve by so on and so forth, you're going to have some kind of an idea what it is that they're talking about. Or if in the off chance you decide you're going to represent yourself, I don't recommend that. You'll at least have a basic understanding of what it is you're asking for, you're talking about. Okay, so we're going to go over some of the basic legal terms. And once again, this is for the person who may have to get into some form of litigation. Maybe you're going to go hire an attorney. You want to understand ahead of time what it is they're talking about so you can save a little bit of time. Saves you on the attorney fees. Or if you are just dead set on representing yourself as a pro se party, this is going to at least help give you some basic understanding of what these terms mean. This is in no way establishing an attorney-client relationship between you and I or my firm. This is just general information. You can look any of this up on the web if you want to. That's fine. If you do and you find out I give you something wrong, let me know. But I'm almost going to guarantee none of this is going to be wrong. Okay, so first 5 terms we're going to talk about are what... These are not going to go in alphabetical order. These are going to go more in order of process, meaning if you're going to engage in a civil case, this is the process you can expect. So these are the terms you're going to see first. So the first thing you're going to see is the term complaint. Now, what is a complaint? A complaint is a pleading, and we're going to talk about a pleading a little bit later on. But a complaint basically is a statement of facts that's going to place the parties and the court on notice as to what you intend to prove at trial or is going to be proved at trial. So if you end up being the defendant in a particular case, this is what the other side intends to prove against you. Okay, so that is a complaint. Think of it as when you were a child and you were sitting next to your little sister or your little brother in the backseat of the car, and your little brother or sister poked you and you went, "Mom, Timmy or Johnny poked me," and your mom would go, "Johnny, did you poke him?" And they would say, "No." Well, what you've done is made a complaint to your mom. Think of her as the judge, who has then asked the other side for an answer. So we're going to get to that in a minute too. So the complaint starts process, okay? And we're going to get down to the process in a minute. But the complaint and answer or reply are what are known as pleadings, okay? So these are going to initiate a civil case. Now, what's required to be in a complaint? Well, you need a jurisdictional statement. You need to clearly identify the parties. You need to clearly identify why the court has jurisdiction. And then you have to state facts to support claims. Can you do that on your own? I don't know. Can you? What is a claim? Maybe that's a term we'll discuss. Probably not in this video, though. That's a little more in depth. A summons. Now, a summons is a document that's issued by the clerk of court. We're going to talk about their role here in a few moments, but the summons and the complaint make up what is known as process. Without a summons, you don't have process. Without a complaint, you don't have process. You must have both. Otherwise, it's a failure of process. So once your attorney, because you're all going to hire attorneys because you're all listening, once you hire an attorney and they prepare a complaint and a summons that's issued by the clerk, you now have process, and that process will need to be served. Which takes us to the next thing, service. So what is service? Well, service is a term of art, and it's basically how you give a copy of the process to the other party. You have to let them know what's going on. You just can't sue somebody and not tell them you're suing them. That defeats the whole purpose of the Constitution and the requirement of due process. There's that term again. So service. So how do we get service? Well, there's a number of ways we can obtain service. The first way, and the most certain way, is to have the sheriff in the county where the defendant is situated bring a copy of the process to them and hand it to them and sign off on they're going to sign off on the summons on the back where it says return of service, and then they will take that original summons with return and they'll file it in the clerk's office in the court file. And then you have service of process. Notice how those terms all start to fit together. So those are our first 5 terms. If you need to take a moment to rewind this and write those things down, I'll give you a few minutes. If you haven't had time to write all these down and take notes on what I've just talked about, there's a link in the corner that you can go to our blog, and these terms and definitions are going to be there for you. The next set of terms we're going to discuss, the next 5, are jurisdiction, parties, standing, clerk, and judge. Now, these terms are here for a specific reason, and they're in this order for a specific reason. As we talked about with the last set of terms, in the complaint you must make a jurisdictional statement. Now, what is jurisdiction? Well, once again, I'm not going to get into a 1L civil procedure lecture on how do we analyze jurisdiction, but I'll give you the basic rudimentary explanation of what that is. First is subject matter jurisdiction. Subject matter jurisdiction is, does the court have the authority to adjudicate, hear, and decide upon a specific or a particular issue? What that means is, what court are you in? Subject matter jurisdiction is very specific. Subject matter jurisdiction means if I have a case for a divorce and I file it in Superior Court, does the Superior Court have jurisdiction? Well, the answer to that is no. By statute, District Court has original and exclusive jurisdiction over all matters of divorce and family. It is a court of record. So you have to know what type of claim you have and in what court you need to file it. Now that's subject matter jurisdiction. Personal jurisdiction is different. And this is where most people think of jurisdiction. Personal jurisdiction is, does the court have the authority under the police powers to extend its authority and touch a particular person? So, how do we obtain personal jurisdiction? Well, the rule of thumb there is that if the incident occurred, say in North Carolina, giving rise to the claim, then North Carolina will have subject matter and personal jurisdiction over those unless the minimum contacts analysis under the Constitution by the Supreme Court have not been met. That is another talk. That's another discussion for another day. And that's a very in-depth type of analysis. And those can get very lengthy, time-consuming. I've actually been in some pretty expensive litigation just on the issue of personal jurisdiction and minimum contacts. But generally, you're going to be safe if you file your action in the jurisdiction, in the state and locality where the defendant resides, not where the plaintiff resides, where the defendant resides. That doesn't mean that a defendant who lives in a different state can't be hauled into court in North Carolina. It simply means if you file it in that particular state, if they have subject matter jurisdiction, your personal jurisdiction should be good. But once again, it's not so simple of an analysis. You definitely need an attorney to determine that. So jurisdiction is very important. And from a pleading standpoint, it has to be pled properly. And there's a specific format and formulary, magic words, if you will, that have to be in a pleading in order to get a jurisdictional determination. The second is parties. Who are the parties? The parties are the persons involved in the lawsuit. Now, I run across this every once in a while, mainly in custody cases where I have third-party relatives and grandparents wanting to try to assert custody claims. And the question is, are they a true party in interest? Do they have an actionable, ripe, and viable claim? If you're a true party in interest, then you have standing. But again, in custody cases, a lot of times you'll have grandparents that want to step in to try to help out grandchildren, and their standing's not always there. So it's something that requires more in-depth analysis by an attorney. This is, again, why you need an attorney. But basically, a standing is somebody who is a real party in interest. We use a very simple analogy. If you enter into a contract with somebody and they breach that contract, you are a real party in interest because you have an interest in the contract, and the other party is a real party in interest because they have an obligation under the contract. So we see how that works. That leads to standing. Standing, we just talked about, is, once again, do you have an actionable and ripe claim? Now, one of the funny analogies that they brought to us in law school was you don't have an actionable claim if your claim is illegal on its basis. For example, a drug dealer sues somebody who robbed them and stole their drugs and money. Well, the subject matter is illegal to begin with, so you really don't have a viable claim. Doesn't mean you may not have contract standing, but it does mean that the basis of the contract is in and of itself illegal. This was a funny thing they would present to us in law school, and the professors would all end it with a ha ha ha. But they're ending it with a ha ha ha, not because it's outrageous. It really does happen in real life. Next, we have certain players in the court that you need to know about. The clerk. Now, in North Carolina, a clerk is a quasi-judicial official. They can actually hear certain types of cases, such as they can hear guardianship cases, foreclosure cases, things of that nature. So they can actually make quasi-judicial determinations. But moreover, they're responsible for the administration of the particular court. So they're a very important player. And it's very important that you understand who does what. And their assistants make sure that those things on a day-to-day run properly. Clerks are elected officials. Judge. A judge is an elected official. It pretty much stands on its own what a judge does. But important for you to know, in the off chance that you are going to be representing yourself, or even if you are represented, you may not personally address the judge ex parte. Ex parte means by yourself. You may not have communications with a judge outside of an open session of court without the other party present. Kind of makes sense, doesn't it? So, no ex parte communication with the judge. I have actually seen this happen with represented parties where they've shown up to hearings that were continued and try to have a conversation with the judge after the fact. Be very careful. If you have an attorney, if you have me for your attorney and you do such a thing, I will be filing a motion to withdraw on your case. Okay, in our previous videos, we talked about don't do it, don't represent yourself, don't go to small claims court. Okay, now why would we say that? The next person we're going to talk about in the court is the magistrate. What is a magistrate? A magistrate is a hired person, quasi-judicial, under the supervision of the chief district court judge. The magistrate is not an attorney Let me say that again if you weren't listening. A magistrate is not an attorney. If you hear the echo in my voice, I'm telling you this for a reason. I'm telling you this because many times I'll have folks, doesn't matter what type of case this, say, I went and talked to the magistrate and the magistrate said X, Y, and Z. And I'll say, well, that's completely wrong. Well, they say, what do you mean that's wrong? You don't know what's going on because a magistrate, 9 times out of 10, is either a retired or transferred police officer. And police officers are not lawyers. It's important to understand what the role of a magistrate is. Where a magistrate's role in a civil case comes into play is in DSS actions. They can sign an order for removal. In domestic violence protective order cases, they can file and issue an ex parte order for domestic violence protection. They can issue warrants for criminal cases. But in the civil context, they preside over small claims court. Now, they get to go through a 3-week training or whatever it is on how to conduct a small claims hearing. But generally speaking, they're not judges, they're not lawyers, and they really don't understand the technical ins and outs of how the law works. They're given a very rudimentary crash course, similar to what you're seeing here. So, going to small claims court, as we said in the previous, is not something that we ever do. The reason is because you're running the gauntlet because you don't know if you're going to get a magistrate that knows anything. And second of all, 9 times out of 10, win, lose, or draw, you're going to end up appealed to district court from the small claims court. And sometimes it's being removed to superior court, and you've just spent a whole lot of money to do a whole lot of nothing. So, please understand, a magistrate is not a judge. Going to small claims court, you will not see a judge, and you do not address a magistrate as your honor. You do want to show them respect. I always tell my clients, litigants, or anybody else, if they're addressing a magistrate, sir or ma'am, be polite, be respectful. But they are not a judge. They have not attained that status, so you do not address them as your honor. Next term, we're going to get out of talking about persons within the courthouse and in the court system, and we're going to talk about the term evidence. What is evidence? We're going to get into bigger, more specific definitions in some of this and down the road, but generally speaking, people always think I have evidence. Okay, evidence is either testimony or physical documents or items that will tend to show or to prove or disprove something in your case. Now, whether it's evidence or not is a deeper analysis than just that. Just because you have an affidavit from somebody who says, I'm going to give you an affidavit so that you can show the judge how good a person you are, is that evidence? We're going to get to that in a few minutes. But we're going to move forward. Procedurally, subpoena ducis tecum. Some of you may be reading this and have actually received a subpoena before or seen one. And it just says subpoena. But what is a subpoena ducis tecum? A subpoena ducis tecum is an order from a judicial or quasi-judicial official directing you, the person, under Rule 45 of the North Carolina Rules of Civil Procedure, to produce documents or items for trial or deposition. Now, what happens if you receive a subpoena? Well, if you flip that subpoena over, on the back there are a list of instructions. And if there is something that's requested of you that is objectionable, then there is a list of objections that you need to make in writing in proper format. A subpoena ad testificandum is a subpoena directing you to testify. That is a subpoena for you to either come to court or deposition and give testimony. You can have both in one document. When you get a subpoena, make sure you look at the big box in the middle and look at what's checked. It'll tell you what it is you're directed to do. If you receive a subpoena, do you have to comply? The answer to that is yes. If it's signed by another attorney, maybe you're best friends with someone going through a nasty divorce and you catch a subpoena from the other side. Well, you may not like that person or their attorney. You go, I'm not going. Do that at your own peril. You're actually probably going to hurt your friend. Because if you are under subpoena and you fail to appear, one of two things is going to happen. One, the court is going to either allow hearsay testimony or testimony without your presence because you've been commanded to appear and you didn't. Or second, the court is going to issue an order for contempt and order you to appear and show cause as to why you should not be held in contempt, and you could be committed for not complying. So please take it seriously and appear and be prepared to produce. If something's objectionable, you need to prepare or hire an attorney to prepare a proper objection. The last thing we're going to talk about is an affirmative defense. What is an affirmative defense? Well, if you are a defendant in a case or a plaintiff and you're subject to a counterclaim, you may need to assert affirmative defenses. Affirmative defenses are certain legal defenses, technical defenses, that will exonerate your liability, that will wipe out your liability. Do you know what those are? There are hundreds of them. It just depends on what type of case it is. You need an attorney for that. So thank you for tuning into the East Carolina Law Group Self-Help Series. We hope that you found these videos informative and have been informational in helping you determine what your next course of action should be in your own particular situation. If you find yourself needing additional legal help, we're available, and you can set up a consultation by calling our office at 252-453-2273. That's 252-453-2273. Or you can look us up on our website at eastcarolinalaw.com, or you can find us on Facebook at the East Carolina Law Group, and we post regularly on there, sometimes almost daily. We put everything from new legal information to office closures and things of that nature, and we provide updates on things that are happening in North Carolina and in our local district. So once again, if you need to get in touch with us, it's 252-453-2273. The East Carolina Law Group, where your family is our priority.